What do you do if you're an investor in a company that provides medical, psychological, physical therapy, or other clinical services to patients or customers, but you're not a medical doctor, psychologist, physical therapist, nurse, or other licensed healthcare practitioner? In today's video, we discuss how investors can profit from businesses that deliver clinical services and where they get themselves in trouble. Hi, I'm Michael H. Cohen, founding attorney of the Cohen Healthcare Law Group. We help healthcare industry clients navigate healthcare and FDA legal issues so they can launch or successfully grow their health and wellness product or service. Two psychologists and an investor walked into a bar. Well, they walked into a conference room. The three decided to form a company that would offer mental health care counseling services. The counseling company, as it were, leased space, and the two therapists started seeing patients and customers for behavioral health. Some of the mental health care counseling was done online via telehealth and telepsychology, and some of it was done in person. About a year later, the investor read an article on the prohibition against, not liquor, but the corporate practice of medicine. He wondered whether he should sell his shares in the company, whether he was in trouble, what he should do. Whether the company itself was practicing medicine, psychology, chiropractic, physical therapy, the legal analysis would be somewhat similar. There are three legal rules you need to know. First, in most states, in order to provide professional clinical services, an individual must be licensed. For example, a licensed medical doctor, MD, chiropractor, psychologist, physical therapist, acupuncturist, so on. Second, the licensed practitioner, nurse, whatever healthcare provider we're talking about can practice either as a solo practitioner or through a professional corporation or PC. Putting these two rules together, the investor cannot be a shareholder in a professional enterprise, and the two clinical providers should be providing healthcare services through a professional corporation, not through a partnership, not through a general corporation, not through an LLC. And further, general corporations or LLC cannot practice a professional service. To be sure, having the wrong entity is somewhat of a technical violation, which potentially can be cured by amending the Articles of Incorporation, but it's also possible that regulators will seize on having the wrong corporate entity as proof of a violation against corporate practice. The third rule to know about is that some states allow professional corporations to mix and match healthcare providers. So, for example, in California, under the Moscone-Knox Professional Corporations Act, a nurse could be a shareholder in a professional medical corporation. This rule creates a lot of strategic possibilities, but you have to watch for potential power plays like the one we're witnessing right now, and legal challenges by the minority shareholders. In our practice, we've seen clients come in with entities formed by corporate lawyers who know nothing about healthcare law. So they might say, form a Delaware corporation is the best, or form a Nevada C corporation. It's absolutely the way to go, but with this kind of thinking, they typically go awry. If you have more questions, give us a wave, pull my ear, contact us at cohenhealthcarelaw.com/listen to what I'm saying, contact, to send us a message or book an appointment. So here's to the success of your healthcare venture. We look forward to speaking with you soon.